you're just an individual that continually commits crime. There's nothing that we have done, whether it be jail, probation, any kind of that changes anything. You just keep committing crimes.
This is People versus Corey Powell, 23S30450 and 22-29300. He appears via video. I've provided a written copy of information. Do we have the reading on the new file?
I don't have that.
I just gave it to you on the thing over there.
Oh, here it is. I'm sorry. Yes, I will waive the reading.
So it's an arraignment on the new one, Judge, and then I believe they want a status conference in a month, so that would be 9/14 on both files.
That is correct, Your Honor. We would request a status conference on both, enter a plea of not guilty on the new file and ask for a status on both.
All right, so as it relates to file 22S29300, Mr. Powell, you are being supervised for the underlying charge of resisting, obstructing a police officer as a maximum penalty of 2 years. Do you understand that?
Yes, Your Honor.
All right, all right. Are you waiving the reading of these, Ms.
We will, Your Honor, yes.
Okay.
Your Honor, he's already been arraigned on the,
Yeah.
he's already been arraigned on the probation violation file.
Oh, okay.
Your Honor arraigned him already. The arraignment was set for the new file.
All right, so then the new file is 23S30450FH. Mr. Powell, in this new file, charge one or count one in this file is possession of methamphetamine. That's a 10-year felony and or a $15,000 fine. Count two is possession of ammunition by a felon, a 5-year felony and or a $5,000 fine with mandatory forfeiture of the weapon or device. Also, you're charged as a habitual offender, second offense notice. And that means the penalties that I just read to you in 1 and 2 are 1.5 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. That's a long way of saying as a result of the HOA2, count one is punishable by up to 15 years and count two is punishable up to 7.5 years. Do you understand the nature of the two charges, Mr. Powell?
Yes, Your Honor.
Do you understand the maximum penalties?
Yes, Your Honor.
All right. And Ms. Shear, pursuant to your comments earlier, I'll enter a not guilty plea to those two charges on your client's behalf.
Thank you, Your Honor. My client, Your Honor, would like to address bond in the files.
Let's first start with, what is our new date?
9/14.
9/14.
9/14, okay.
Then we had the discussion at the bench. Apparently he needs some time to consider all that we talked
Okay,
about.
that's fine.
Yep.
23, all right, and bond.
Your Honor, in the file 30450, there is a 15,000 cash surety bond set in that matter. In the probation violation file before Your Honor, there is a $50,000 cash surety bond set in that matter. We would ask court to consider a reduction in both of those bonds. Mr. Powell has been essentially a lifelong resident of Montcalm County. He's lived in the same home for approximately 8 years. He has 2 minor children. He has worked for himself in the construction business for approximately 25 years. He's, I don't believe, a flight risk. Clearly, he would still be on probation, so he would be supervised in that fashion, as well as any terms and conditions that this court set forth in any new bond or any new condition for him, which he would abide by and appear for court. Again, he's grounded here in the community and has family here, including young children. So we would ask the court to reduce the bonds in both files in this matter pending further proceedings.
Ms. Krause?
So Judge, just in the probation violation file alone, I mean, you got allegations of failing to report, failing to change his address, being outside of his curfew, failing drug tests, having contact with other felons. I mean, the list goes on here. Possession of meth, possession of heroin, possession of narcotic paraphernalia. Again, I think the bond in that one is more
I
than.
don't know whose you're reading.
Yeah, that's not mine. My address is current.
Mr. Powell, Mr. Powell, stop.
That was Benoit.
So Mr. Powell is alleged to be in possession of methamphetamine. He was in possession of paraphernalia also, it looks like. He was avoiding the troopers when they knocked, apparently, if I believe the description. Found 22 caliber ammunition there. Also with a felon, apparently Miss Stanwood.
No,
So I was sort of right, some of those.
no,
I got it.
there's no allegation that he was with the felon.
Okay, but he's still in possession of drugs, the ammo, he had verbal contact with Rebecca Swartwood.
Okay, but count 4 says this: you must not have verbal, written, electronic, or physical contact without permission of your field agent with anyone you know to have a felony record. And then it goes on to say that on 7, Mr. Powell,
Okay,
please don't talk when the court is talking.
I'm sorry.
It goes on to say that on July 18th, he had physical and verbal contact with Rebecca, like I said, Swartwood, who was found to be in possession of methamphetamine. So maybe I'm reading count 4 wrong, but how does that square with the idea that he's with a felon?
He's not with a felon, Your Honor. He was with Rebecca Swartwood, who was charged at the time with a felony.
Okay, even if you get rid of that one, Judge, let's just say we don't have that one. We have all the other stuff and
He
he
clearly
committed
doing
a
it, I
new
was just
crime.
reading it from here.
And he committed a new crime. So, I mean, again, the bond on that one is reasonable given the the other allegations and the fact that he's committed a new crime. So we would ask that the bond remain.
All right, so Ms. Shear.
Your Honor, I would stand on the statements I made earlier. Again, I would ask the court to consider a reduction for all of the reasons that I had set forth earlier.
All right, so Mr. Powell's being supervised for the underlying charge of resisting and obstructing a police officer. We now have new allegations that involve drugs, ammunition, and apparently somebody else that he was in contact with who was engaged in committing a felony, rather than that individual being a felon themselves. All of that leads to the conclusion for the court that in viewing this through the prong of bond, protection of the public, and appearance of the defendant, I haven't heard anything that is directly impacting whether he's likely to appear, other than the idea that generally felons that are messed up or mixed up with guns and drugs might have a tendency to fail to appear for court dates. But I do have plenty that suggest that he is a danger to the community as it relates to being on circuit court probation, a felon, in other words, and new allegations that involve ammunition and drugs. So respectfully, Ms. Shear, the court's not going to modify the bonds, and maybe an argument could be made that it ought to be higher. What else do we have?
Can you bring Kane out of his breakout so we can do him and after you do whatever Mr. Blaze does? Well, it's gonna take a minute to get out of the breakout room. Go ahead.
Tom,
S 30450 and 22S 29300. My understanding, Ms. Shear's here in the courtroom, Mr. Prowell's in jail. That's my understanding. He's gonna plead guilty on both files. He's gonna plead guilty on the probation violation file, and he's gonna plead guilty on the new case to count 1, possession of meth. We'll dismiss count 2.
No. It was an attempted count 2.5 years.
Okay, you're right. He's gonna plead guilty to attempted possession of ammunition, which is count 2. So we're gonna dismiss count 1, the possession of meth. Attempted count 2. And dismiss the HOA. Now, we've agreed to an 11-month sentence, I believe, on the probation violation. And that we would hold off on the time on the new case so that we didn't use up all our jail time. But it's a jail probation to be a sanction case.
Yeah, so essentially in the probation violation file, 22-29300, he's gonna would plead to count 2, which is the counterpart to the new charge in the new file. The rest of the case charges there would be dismissed. He would then plead to the attempt count 2, as Ms. Kraus indicated, dismissing count 1 in HOAs. He would get an unsuccessful discharge with an 11-month sentence in the PV file. And then he would be subject to probation, fines, costs, intermediate sanctions in the new file, and time served at date of sentencing on the new file.
Correct. So that you're holding off, reserving any more jail time on the new case for later.
So what comes to mind for me, Ms. Vanderveen, I thought if we have somebody on supervision, guns, ammunition, is supposed to be a prison sentence.
Why?
Supposed to be, isn't it required?
Not required, but recommendation, or is that just parole?
I think it's more geared towards parolees, but we do tend to do a little more harsh punishment for those on supervision.
Okay, I guess we'll see. I'm probably guidelines on an attempted count 2 or
I think when you
Zero to something.
see the facts of this case, Judge, you're gonna not think prison.
all right. So is that the extent of the agreement?
Yes, Your Honor.
All right, you're Corey Powell.
Yes,
That's your understanding of the agreement.
yes, Your Honor.
Raise your right hand. I'll have you sworn.
Yes, Your Honor.
All right, you have any questions about anything we've done on this file so far?
No, sir.
All right, how do you plead to the charge of attempted possession of ammunition by a felon?
Guilty.
The information says this occurred on or about July 18th of this year in the township of Reynolds, the county of Montcalm. Is that the correct date and location?
Yes.
That date and location, can you tell me in your own words what you did to be guilty of this crime?
There was 322 shell, 322 ammo shells found in a junk drawer in my garage. That it was in my garage, so.
All right, and is it accurate that when these shells were found, that you were a felon and you had not attempted to or even regained your eligibility to possess ammunition? Is that accurate?
Yes, Your Honor.
All right, Ms. Kraus, anything else on the
No, Your
facts?
Honor.
Ms. Shear?
No, thank you.
Mr. Powell, other than what we've talked about here this morning, has anybody else promised you, threatened you, or done anything else to you to get you under this plea?
No, sir.
Other than what we talked about here this morning, has anybody else said anything to you about what your sentence might be?
No, Your Honor.
Okay, Ms. Kraus, are you aware of any other promises, threats, or inducements?
No, yeah,
Ms. Shear?
No, Your Honor.
Ms. Kraus, is the court complied with the court before taking a plea?
yes.
And Ms. Shear?
Yes, Your Honor.
All right, Mr. Powell, do you have any questions now that we finished this on this file?
No, sir.
All right, last question. Do you want the court to accept the plea to count 2, an amended count 2 of attempted possession of ammunition by a felon?
Yes, please, Your Honor.
We'll accept your plea. You did offer your plea freely, accurately, voluntarily. Now let's turn our attention to 22S2933, I'm sorry, 300FH,
He's gonna plead to count 2 of the PV.
the 29300. So Mr. Powell, on this file, you are being supervised for the charge of assaulting or resisting or obstructing a police officer. That has a maximum penalty of up to 2 years. Do you understand that if you go forward with your plea, that you could be resentenced on that underlying charge, which has a penalty of up to 2 years?
Yes, Your Honor.
All right, and on this file, are you waiving your right to have a hearing as it relates to all, it looks like 8 counts of probation violations?
Yes, Your Honor. I'm waiving my right.
All right. All right, by waiving your right to have that hearing, that means you'll waive all the rights that come along with the hearing. They're exactly similar to, well, they are almost exact, but we'll go over them as your trial rights. So it means you're waiving the right to be presumed innocent of the charges. It means you're waiving the right to confront witnesses that are called against you or to call your own witnesses. It means you're waiving the right to have the, or to testify at a hearing of that nature or not to say anything, and the trier of fact, meaning the court, could use that against you. It also means you're waiving the right to have the assistance of an attorney for a hearing of that nature. Are you waiving all those rights that would come along with a hearing?
Yes, yes, Your Honor.
All right. Has anybody promised you or threatened you or done anything else to you as it relates to this file to get you to consider entering this plea?
Nah, other than what was already mentioned, no.
Okay, so what's already been mentioned on the record, has anybody else said anything to you about what your sentence will be as a result of entering a plea on this file?
Yes, so it's my belief that it will be just the remainder of the 11 months with time credited for 180 days.
That's what's been placed on the record. But other than that, has anybody else,
No,
anybody else said anything to you about what your sentence might be?
No, Your Honor.
Okay. You recognize, Mr. Powell, that going forward with your plea on this file or even the other one, the recommendations, the agreements are not binding on the court. And if you go forward with your plea, the court on this file is going to be free to sentence you as it sees fit. You understand that?
I don't understand what you're saying, sir. You're saying
So
you're
on this
not gonna go
probation
with
file,
or-
hang on, let me finish. If you go forward with a plea, the
Right.
court's going to be free to sentence you as it sees fit. Do you understand that?
Yes, Your Honor.
Okay. All right. Let's talk about the charge then. How do you plead the charge in count 2 that on or about July 18th of this year, you violated a criminal law of any unit of government when you were in possession of ammunition by a felon?
Guilty, Your Honor.
Okay, so I know that I just heard it, but I want to make sure we're on the same page. I assume it's the charge that you just pled to. So is that accurate that some ammunition was found in a drawer in a garage?
Yes, in the junk drawer in my garage, there was 322 caliber bullets found.
All right, so I do find a factual basis for the same. Ms. Kraus or Ms. Shear, anything else on the facts?
No, yeah.
No, thank you, Your Honor.
Okay, Mr. Powell, back to you. Other than what we've discussed here this morning, again, I want to make sure, has anybody else promised you or threatened you or done anything else to you to get you to enter the plea on this file?
No, Your Honor.
All right, and other than conversations with Ms. Shear or even your agent, has anybody else said anything to you about what your sentence might be?
No, Your Honor.
All right, very good. And so on this file, Ms. Kraus, are you aware of any other promises, threats, or inducements?
No, yeah.
And Ms. Shear?
No, Your Honor, but I think we did put on the record on this one that the prosecutor's agreeing to the recommendation. So no, other than that, no, Your Honor.
Okay. Then, Mr. Powell, back to you one more time. As far as the probation file now, do you want the court to accept your plea to count 2 violating a criminal law of any unit of government?
Yes, I would appreciate it if the court would accept my guilty
I-
plea, sir.
I will accept your plea. You did offer your plea freely, accurately, and voluntarily. So what I'm gonna need is, well, I don't think we'll need anything. I've already got a report
Well,
here.
we're gonna adjourn for sentencing.
Right, an updated one, and then, if required, and then we'll get a pre-sentence report on the new file. And I'll just make a note that this will be adjourned to a later date and time. Mr. Powell, it's usually about 4 weeks, okay? So I'll see you in about 4 weeks.
All right, thank you, sir,
Yeah.
for your time.
All right, these are the cases of the people of the state of Michigan versus Corey Powell. One is 23S 30450. The other one is 22S 29300. He's being sentenced on both. One's a new case, one's a PV. We ask that you follow the record.
All right, Mrs. Shear, then first of all, have you had it, as it relates to the new case, have you had adequate opportunity to review the pre-sentence report and the sentencing information?
Yes, Your Honor, and there are no factual additions, corrections, deletions.
And then I assume then you also had a copy of the probation violation.
Yes, Your Honor, I have, and Mr. Powell and I have reviewed that much prior to today as well. When we were here, as a reminder, Your Honor, I believe it was our very first or maybe our second appearance on this case. The recommendation that was put forth had the jail credit. Mr. Powell was only granted jail credit for the time he actually physically sat there. I believed that he was entitled to the good time credit as well. The court indicated that if there was some authority that we had to grant that, and I do have that, People versus Wrestler, which is at 210 Mishap 24. It's a 1995 case, which is still good law, indicates that the defendant is entitled to the good time granted by the sheriff. So Mr. Powell's total credit in his probation violation file should be, if my math is correct, 266 days. He was sentenced to 6 months by this court and earned his good time. So that should be the 180 days for his original sentence. And then he's been sitting since July 18th, this additional 86 days since his arrest.
Ms. Kraus, do you concur with that?
I don't know the case, Judge.
I don't know either. She's just giving it to me now.
I have a copy here, Your Honor. I had it in another case with Judge Krieger just probably a month ago. It's fairly.
So you had indicated earlier then, request to file the recommendation. So here's my struggle with this. The defendant was on probation when he commits this possession of ammunition by a felon. 21 misdemeanors, 2 felonies, as I mentioned, on supervision. This is one of those cases where I think the public just would scratch their head and say, how is it possible that a felon, 2 prior felonies and 21 misdemeanors, he's only 45. That means that in essence, Mr. Powell, just about 21, was it 23, every year of his adult life commits a crime in which he's convicted. That wouldn't count all the crimes that he's committed that he doesn't get convicted. That's just conviction. That means he's just a career criminal who's not a very good criminal because he gets caught almost every year of his adult life. And he has a guideline range of only 0 to 9. We've been through this whole thing with possession of guns or ammunition by felons. What's your thoughts on that when we're at time served? I guess that's the recommendation.
Well, no, it's 11 months on the PV. And
Right.
remember, we were putting all the time on the PV to keep your jail open on this one.
Yeah, well, that's true, but now we have this argument that he's got 266 days served.
True. We just approached for site.
All right, so Ms. Crowe, anything else from the people then?
No, yeah.
Ms. Shear, any elocution on behalf of your client?
Your Honor, again, I'm just asking the court file the recommendations in both cases, and again, grant the pursuant to the case cited, grant the 266 days credit in the probation file.
All right, Mr. Powell, anything you want to say on either file?
No, Your Honor.
Mr. Powell, I'm going to file the recommendation, having discussed at the bench a few other things here. I can't tell you, though, that it changes anything about the court's frustration. You're just an individual that continually commits crime. There's nothing that we have done, whether it be jail, probation, any kind of that changes anything. You just keep committing crimes. And then when we throw in the idea of ammunition, I recognize that this is a bullet found in a junk drawer, but that all is precipitated because you got all these alcohol bottles at your residence, which sort of precipitated the search. I just don't understand it. I don't understand how we got to a place where guidelines are so minimal for felons that are continually committing new crimes. But I'm going to place you on a period of supervision. I guess we'll give you the opportunity to get the probation right. Getting probation right starts with the idea that we can't commit new crimes while we're on supervision. I'm going to place you on a period of supervision for 3 years. Sir, you should be familiar with all these terms of supervision. They're standard. They're going to mirror what you were already doing. So obviously there'll be no drugs or alcohol while you're on supervision. You are a felon. You should understand that. So you can't possess ammunition. You can't possess firearms. We'll test you randomly for drugs or alcohol. While you're being supervised, these supervision fees will be $30 per month. There'll be a curfew of 10 p.m. to 6 a.m. The court's going to require that you maintain employment of at least 30 hours a week, or a combination of supervision obligations and employment of 30 hours per week. Sir, I will impose a $130 crime victims assessment. I'm required, and I will impose a $68 state cost. There'll be attorney fees of $400, a fine of $500, court cost of $550. On this this file, the court's gonna impose a sentence of 86 days. This is in accordance with your agreement. In the Montcalm County Jail with credit for 86 that you have previously served. Turning our attention then to file number 22S 29300. Court's going to revoke unsatisfactorily your supervision.
Thought we wanted.
On this one, we're revoking.
We weren't gonna keep them on both, because that had.
No.
Well, then I'm following the recommendation. That's my understanding of the agreement. It says it's revoked.
I had a question mark about whether we wanted to revoke probation on that one.
Well, I just put him on, and
I
this
know.
is a 2-year also. He was only
Okay,
on
okay,
supervision.
that's fine.
So revoke unsatisfactorily your supervision. I'm gonna reassess any outstanding fines, costs, or other monetary obligations. And then I'm gonna sentence you to 266 days. I'm sorry, I'm gonna sentence you to 11 months in the Montcalm County Jail with credit for 266 you have previously served. On both of these files, you have a right to seek appellate review. If you'd like to do that, you have 21 days from today's date to make that request. And if you want a court-appointed attorney to assist you, you have a broader window of 42 days, so 21 and 42. Anything else from either side?
No, thank you, Your Honor.